everybody, time for another question from the Lorie Burch mailbag in our recent edition of Hot Topics in Estate Planning and Probate. So this question reads, Dear Lorie, my wife and I had joint estate planning documents created several years ago when we were married. Unfortunately, we are now in the process of a divorce, and I was wondering if you could provide some insight on how to go about revising these documents to reflect us separately. Thank you for all your help during this difficult time. Matthew in Dallas, Texas. Well, thank you, Matthew. You know, one of the things I learned early on with my practice, the very first time I had somebody call me and say that they were getting divorced and needed to update their will, my first response was, "Oh, I'm so sorry." And she said, "Don't be, I'm not." So now I tell people, congratulations. So Matthew, congratulations. But I'm glad you wrote in because it is an important trigger to make sure that you update your estate planning, or if you haven't done it in the first place, to make sure that you get it done. Some of the reasons why is a lot of the times when you do estate planning, especially if you have kids and you're picking trustees and guardians and executors, even when you're doing medical power of attorney, designating who can make medical decisions, a lot of the times you decide upon family members of your spouse. So you may not have those wishes now that you are divorced. So it's not just a matter of taking your soon-to-be ex out as executor, medical power of attorney agent, what have you, but it's also a matter of taking an examination of who else you've named in there, because it may be someone attached to your wife that you no longer would want to do that. Another thing is, don't forget about your updating your beneficiaries on life insurance, retirement, bank accounts, investment accounts. Important to make sure that you address that as well, so it no longer has your former spouse. Another thing to keep in mind, whether you update it or don't have anything in place at all, let's say you do have a minor kid, you pass away, a judge is going to have to step in and appoint who will oversee money and everything, and it's very likely that they'll pick their parent, which is your ex. So again, another reason to make sure that if you passed away, that your ex is not the one who would control any money or property of yours for your kids. So another really good reason to have it. And then finally, one thing I've run across, which I don't really get, but hey, to each his own, I have a number of people who have gotten divorced but still want their ex to be executor, to be medical power of attorney person. And that's fine, but the worst thing you can do is say, well, I'm not going to change anything because it already has her or him. No. The way that it works automatically is it will eliminate the spouse from there. So even if you want to have your ex listed to make all these decisions, you need to update it so you can at least reflect the fact that you are divorced now, but you still want that person to make decisions for you if that's what you choose. Doesn't happen a lot, but it happens enough that it makes me want to mention it for you. So great question, Matthew. I congratulate you again on your next step in your journey, so best of luck to you. If anybody has any other questions for the Lorie Burch mailbag, please feel free to submit them via my Facebook page. Don't forget to like us on Facebook, and for other hot topic videos, you can check out my YouTube page. And remember, until next time, if you don't have a will, the state of Texas has one for you.